All right. The Trump administration argued Wednesday that the court case on its immigration restrictions is simply too important for the Supreme Court to ignore in its final filing before the court decides whether to take up the case.
Joining us on the Kogo News Live line, immigration attorney and an adjunct professor of law at SMU, Eric Cedillo. Good morning, Eric.
Good morning.
Now, the justices met yesterday morning for their last regularly scheduled conference. Is it safe to say they've made a decision on this?
I think so. It's probable in terms of whether or not they've decided to issue the writ and actually hear the oral arguments in October. And they probably made a determination, I would imagine, on whether or not they're going to allow the ban to continue. And we will probably know that either today or most likely Monday morning.
So what are their options at this point?
Well, what they could do is, again, if they grant the writ, then they will hear arguments in October. Now, theoretically, they could maintain a special session and hear it over the summer, but that's probably not going to happen. I think the big thing, the administration has asked for them to consider basically allowing the ban to continue until they hear oral arguments in October. That would take 5 justices to make that happen. So it could be really telling. They could just come out and say, hey, look, we're going to allow the ban to continue. That means that 5 justices determine that it should go forward, or, which is probably more likely, they will grant the writ of cert and hear arguments in October and not disturb the stay that is currently in place by the Ninth Circuit and the Fourth Circuit Court of Appeals.
Now, let's say they did decide to take it up in October and maybe it was one of their first cases and made a decision. If they decided to go for the travel ban and say, yes, this is legal under the Constitution, how quickly could we see it reinstated?
Well, that's the thing. I think initially the administration said they needed the 90 days. They needed the 90-day ban to look more closely at super vetting of the process that were involved. There was some back and forth with respect to the Ninth Circuit in terms of whether or not that stopped the administration for looking at that extreme vetting. The Ninth Circuit came out and said, well, look, if that was a consideration, then don't worry about it, administration. Do what you need to do to look at the vetting. So at present, there is no question that they have the ability to look at this thing. So by the time, October rolls around, this may all be a moot point. If the Supreme Court just says, well, hear oral argument, we're not going to allow the ban to continue currently, this could be all moot by October because the administration does, in fact, have the ability to look at whether or not their vetting process is appropriate.
All right, Eric, thank you so much. Eric Cedillo, immigration attorney and an adjunct professor of law at SMU.